Well, good afternoon. I would like to welcome all of you here to today's Law and Business seminar at Monash Law School. So I'd like to welcome you on behalf of the Law School and on behalf of the Centre for Commercial Law and Regulatory Studies, CLARS. Our seminar this evening is on the role and effectiveness of ASIC compared to the SEC, very topical subject. And our speaker tonight is Zehra Kavame Eroglu. Now, Dr. Eroglu works in the area of corporate governance and financial market regulator. She is director of the Master of Accounting and Law at Deakin Law School, and she's only been in Australia since 2017. A decade earlier, she received her Bachelor of Law from Berkshire University in Istanbul before heading to New York to complete her Masters of Law at Columbia Law School, where she subsequently became a postdoctoral research scholar at Columbia's International Investment Center. She then, clearly liked New York and stayed on to do an SJD at Fordham University, working closely with a colleague that I know very well, at Fordham, Professor Martin Gelter, who is one of the leading comparative law scholars in the area of corporate and commercial law in the world. I note from Zehra's CV that she's also worked as an assistant to the Honourable Justice Ruth Bader Ginsburg when Justice Ginsburg was teaching a course in Istanbul. So we might have to ask you questions about that later, Zehra, in the question time. Zehra's going to speak for about half an hour, and then she's going to be followed by a commentator who really needs no introduction to any of you, Kathy Armour. Kathy, thank you very much for agreeing to be a commentator for today's seminar. Kathy is a graduate of ANU and my old alma mater, Sydney Law School. She's been at ASIC Commissioner since 2013. And prior to that, Kathy was General Counsel for Macquarie Capital and an Executive Director of the Macquarie Group, advising on equity, debt and private capital markets, mergers and acquisitions, etc. Kathy previously worked in private legal practice for what is now King & Wood Mallisons and Allens in Sydney, and she also worked in New York for Milbank Tweed. So Kathy's going to talk for 15 minutes after Zehra's presentation. We are going to have plenty of time for questions. You are unfortunately all muted, so I'd like you to, if you do have questions, please send them through to me as the sessions are going on or as the speakers are speaking. You need to use the Q&A box, however, at the base of your Zoom screen to send me questions. And if you could please identify yourself and your organisation when you send through the question, and then we'll see how many of them we can get through with our speakers. So Zehra, I'm going to pass it over to you now, and thank you so much for coming today.
Thank you so much. Thanks a lot for this really nice introduction and having me in your seminar series. I think they're fabulous, and it's a privilege. It's a joy to be part of this. Also, I have to thank Kathy Armour for accepting to be my commentator. It's more than exciting. It's thrilling to have her. I can't wait to hear her comments. So that's, I look forward to hearing her. I hope I don't rush and I don't talk too fast to reach her part. Finally, I also want to thank, finally, before starting my presentation, I want to thank my co-author on the paper, Karen Powell, especially on her comments on state versus federal level enforcement activities in the US, which we don't have here in Australia. And I think that only indicates that we are expecting even more from ASIC. So that's an important contribution, I believe. I quickly want to tell you why I decided to write the paper. What happened is almost everything I've been hearing since the beginning of Hain Royal Commission kind of rhymes with what I have observed in the US for over a decade, especially with the global financial crisis, which actually is like a year after I arrived in New York. So I was right in the middle of it. It's an interesting experience, least to say, but it kind of, I constantly had the feeling of a deja vu. So I know the institutions are different, it's a different country, but all the arguments, all the discussions that we were hearing, I mean, kind of reminded me that we have been seeing over a decade in the US. So I wanted to compare SEC with ASIC to have a better insight of how we can strengthen our enforcement actions. Looking at the global financial crisis, 2008, when SEC of the US was harshly criticized for weak enforcement actions against wrongdoers. Lack of enforcement, SEC not being tough enough was mentioned many, many times in those days. Everyone harshly criticized SEC, and there is one interesting example. So Goldman Sachs case is in 2010, when Goldman Sachs agreed to pay $550 million US dollars to settle the claims. And the claim was that Goldman Sachs misled investors in a subprime mortgage product, which is heavily linked to global financial crisis. So the payment then was among the largest settlement amounts. There are larger amounts later on, but when it had happened, that was a record-breaking amount. So yay, let's celebrate, right? $550 million settlement, that's awesome. But when you look at the profits of Goldman Sachs, Goldman Sachs had reported 13.39 billion US dollars in profit the prior year. So 550 million out of 13.39 billion sounds really small. I mean, it's not a big financial burden for Goldman Sachs. So as if, in spite of having the then largest settlement amount, SEC wasn't off the hook. Still, criticisms continued, and one of the reasons was that SEC declined to identify and hold individuals criminally responsible for fraud. So let's jail them was the discussion all the time that we were hearing then, right? And of course, there are many more examples. As a matter of fact, after the global financial crisis, Bank of America, Goldman Sachs, Citigroup, JP Morgan Chase, and all settled charges. But the issue was that the settlement was without admitting or denying guilt. I hope now you're already hearing why it kind of rhymes. So turning to ASIC after the Royal Commission, yes, ASIC is harshly criticized. And looking at the misconduct and the scale of wrongdoing discussed in the Royal Commission report, I mean, yes, it's heartbreaking, but it's also often argued that ASIC could have engaged in much higher level of enforcement, such as suspending licenses, obtaining court orders, and more on. So eventually, Commissioner Haynes said ASIC rarely went to court, and ASIC actually now faces the exact same criticism that SEC faced after the global financial crisis. A couple of points I'll make throughout the presentation and compare ASIC with the SEC, but first I want to talk about the right balance of regulation and enforcement, how regulation works over time, and I have to say even hours of discussion will not be enough. Let me quickly share my screen. I have a couple of slides on that. I think I managed to do that, I hope. So what I want to say is that as something that's really important for our discussion is having a right balance of regulation, which will allow us with strong and relevant enforcement. So there is a problem here because it's so hard to find a balance of regulation. And if you look at the history, it's kind of regulation and deregulation keeps continuing. And it's not a criticism, but a fact. The cycle of regulation and deregulation is something that we should expect. And it's kind of a vicious circle for various reasons. First one is that it's a reaction to past, and it's always, there's always change, right? The world is changing. And honestly, finding the right balance is easier said than done. think about technological advancements, globalization, new products, new market players, and complexity of the markets, innovations such as crowdsource funding, cryptocurrencies, a lot of regulation. And it's all expected from giant regulators that we have around the world now. It's ASIC, it's SEC. And they all are facing all these problems of, constant change. And interestingly, when you actually look at different jurisdictions, especially when comparing ourselves with different jurisdictions, what we find is that regulation and deregulation cycles often rhyme too. So like 1980s, deregulation in both jurisdictions, you will see that. So it's kind of a global fact that we will have these cycles. Okay, so I will keep it short, I promise. This slide is already too wordy, but I have to say it can be even more. But what I want to say here is that when you look at the past 40 years, a lot changed in Australia. Starting from with deregulation in 1980s, efficient capital market hypothesis. And what we said was, if ain't broke, don't fix it. And thinking that market will fix itself. They will discipline themselves. So 20-something years of deregulation ended up with the creation of ASIC and APRA, the Twin Peaks system, and then starting regulating and regulating more and regulating more and making the system more and more complex. So I think we are at a point that we already are now talking about deregulation, but we are at a level where it's almost impossible to do. Why I said deregulation, I have to say it upfront because many people will quickly argue that it's not really deregulation. So what Commissioner Hein said is that regulations are already complex. Adding more and saying don't do it, which is already stated, will only add an extra layer of complexity. And he asked if the laws should be simplified to reflect those ideas. And there, I actually have to say, again, easier said than done, while we are even talking about the possibility simplification or deregulation, we are already regulating even more. One example I can just quickly give is BEAR. So APRA was tasked with overseeing BEAR. Now it's first in turn to FEAR and then FAR. So now ASIC has to regulate and oversight that too. And so even when we're talking about deregulation, we are actually ending up regulating more. And then it's even more complex when you think about regulation at the international level. Anti-money laundering, for instance, is a good example here because in many instances you have to coordinate, you need to coordinate and cooperate at the international level. So the more no matter how much we want to simplify or deregulate, we are at a level where the markets and the systems are so global and so complex, and innovation is at a level that is so unprecedented that we end up regulating and regulating. Commissioner Hein asked whether enforcement should be different. And I think that's where the paper becomes really important because we need to understand how we can enforce or administer these laws and regulations differently. ASIC quickly responded to that with a why not litigate approach. And it's welcomed because what we wanted ASIC to be, stand tall, be stronger, have harsher enforcement. But how we do that is basically, ASIC describes it as a renewed enforcement approach, establishing an office of enforcement within ASIC, accelerating enforcement outcomes, and strengthening penalties available. This is where I need to stop for a minute. I will get back to this enforcement and why not litigate approach in a few minutes. But let me quickly tell you about SEC and how this vicious circle goes over there. The slide is even crazier because it's also another snapshot of only the two examples I want to give, and it actually starts from 1930s, not even 40 years as we had in ASIC. So maybe I should have even more, but it will be impossible to cover them all now. So the quick two examples about regulation and deregulation and how it's a vicious circle is here. First one is the Glass-Steagall Act, which is an act from 1933. It actually was separating investment and commercial banking activities. But what happened in 1980s and 90s is that with the deregulation, the repeal of the Glass-Steagall Act made this separation blurry, and actually this repeal was considered to be among the core reasons of the catastrophic effects of the global financial crisis. Add to that this investment and commercial banking activities separation becoming blurry. Add to that the minimum capital requirements. So in 1970s, this is the second example. In 1970s, there was a minimum capital requirement imposed, but by 2000s, investment banking firms were exempted from the minimum capital requirements, and then we had the global financial crisis, and all of a sudden we ended up having minimum capital requirements imposed again, and actually with Basel, 2 and 3, and it goes on. It's even more and more confusing now. So it's kind of a vicious circle wherever you go, and it's kind of a fact with all the things that are changing, and we have to be aware of that. That it's most likely will be like that. There will be deregulation and then regulation. Politicians change, things change, and it will happen. What I want to move on to next is to show what SEC did after the global financial crisis, and then I think why I keep saying it kind of rhymes will be clearer there. It's so loud over there. So in the wake of the global financial crisis, SEC adopted an investigate to litigate approach. And they said it means being trial ready. I think this is really important. So, and looking at what happened after the Royal Commission, what happened in ASIC, this is really timely to discuss that. What did SEC do on those days can be illuminative. So the new investigate to litigate approach meant that there will be SEC will be building stronger cases with ability to prove the misconduct in courts, and that will actually help us to be stronger. We have a stronger standing in these cases. And many thought that initially that means that there will be no settlements anymore and everything will be litigated. But trial ready doesn't mean that everything will be litigated. Trial ready is, I think, self-explanatory. It means trial ready. It doesn't say go and sue everyone in every second. But how can one be trial ready should be the question. Then SEC explained what trial ready means. First, there will need to be additional staff building those cases and making sure that the cases are trial ready with extensive investigations, long hours of commitment. And it's not just additional staff, it's also support from Congress to courts. So it means having more judges, having enough budget, having enough staff. And maybe even more importantly, this is not a one-time support. The support has to be continuous. So increased budget and staff cannot be for just 1 year and then it will go back to original, earlier numbers again. So it has to be on a continuous basis. And indeed, after the global financial crisis, Congress did support this increased budget and increased staff numbers for SEC. And the numbers kept increasing after the global financial crisis, that's for sure. But turning to settlements and turning to the investigate to litigate approach, I think what SEC did is particularly important to compare the why not litigate approach in Australia. as the SEC chair then reported, majority of the cases did continue to settle. There was one difference though. So the no admit, no deny settlements were not as available, especially in cases with harm to large number of investors or significant risk of harm to the market. So the SEC started demanding additional accountability in these statements, in these settlements. And I think this proved to be successful, as the reports show that SEC obtained 77 admissions, 30 from individuals and 47 from entities, just after the global financial crisis. So that's for that period. But let me underline a fact here. In order to get admissions from wrongdoers, SEC had to be trial ready. So looking at the SEC example, I argue that settlements will continue, but we won't see them on a no admit, no deny basis, especially when the wrongdoing is obvious, wrongdoing is continued for multiple years, or adversely affected a large number of people. So in those instances, I do expect ASIC will demand further accountability, admissions. And the only way of getting admissions is to be trial ready. And of course, it doesn't mean that every case will be on an admittance basis. And looking at SEC, majority of the cases actually continue to settle without asking admittance. But there were some major cases that SEC rejected to settle without getting an admittance. I think that was a big change in the wake of the global financial crisis, which can be really illuminative for what we are expecting from ASIC at this point. I have also one more point to add to this complex system in the US, which is basically how financial markets are regulated. The oversight is working in the US. So we have self-regulating oversight mechanisms. We have additional federal regulatory agencies, federal criminal enforcement mechanisms, and very importantly, we have extensive state civil and criminal enforcement mechanisms. So states are heavily involved. And that's also on top of the private litigation opportunities. You know, private litigation is really, I mean, US is very litigious, so that's very common. I think the fact that there is enforcement at the state level is very important because it shows that SEC is not the sole player. And this is very different than Australia. And in the US, there's a big discussion on regulatory competition. You know, some see it's a competition, race to top, race to bottom. Others say it's a complementary action. It's great to have states because if SEC doesn't step in, states can step in. So no matter whether you want to see it as a regulatory competition or burdensome act, a more complex enforcement activities, the fact is that there is strong enforcement at the state level, which is not existing in the US, in Australia. How strong it is, I think there's only one example I can quickly give here. I mean, there are many, but for time limitations, I just want to give one quick example where there was a Wall Street Journal article that said there were abuses in brokerage houses, arguing that SEC failed to properly investigate and enforce. And soon after that article published in Wall Street Journal, New York State Attorney General started investigations. They announced that they are starting investigations. And they looked into the conflict of interest issues in Merrill Lynch. And SEC started investigations a couple of weeks after that. But what happened was an unprecedented global settlement with 10 investment banking firms, and it all happened with a coordination with state securities departments, while SEC did little or nothing. So this strong enforcement at the state level is a very different aspect of checks and balances in the US. and understanding these complementary or completing or competing, however you want to say, these enforcement activities is very important, because not having it all here in Australia, but expecting all these enforcement activities from ASIC indicates that ASIC, it's more is expected from ASIC. So let me stop sharing for a few seconds so that, I mean, if I can manage. Nice. All right, I'll just leave it. I wanted to stop sharing. Oh, here. Sorry. So what I wanted to tell, I have a few more figures that I want to go into, but before that, so far what I wanted to tell is that there is the cycle of regulation and deregulation. There is constant change, and there is differences, different mechanisms working at in different jurisdictions. But what we need to look at is whether ASIC is equipped with what it needs to deliver the tasks that we are expecting. So we need to ask whether we can strengthen our regulators and allowing them do things that we are expecting them to do. If it's not the regulation itself, as we see already, that it's already complex, it's already changing constantly. If it's not the regulation, but stronger enforcement, then how do we do that? How do we ensure stronger enforcement is the question. And there, we need to understand that it's about budget and it's about staff to deliver the task. That's why I think it's important to compare SEC and ASIC. And I have to say it's upfront, maybe, that it may sound unfair in first instance to compare SEC with ASIC. SEC is a giant regulator. After all, US has the largest capital market in the world. Of course, you expect them to be big, large, giant, right? And some of the companies they are regulating are actually bigger than some of the economies of some countries. So we are expecting US regulator to be a giant. Yes, that's true. But then why am I comparing it with ASIC is the question. We are not expecting to have the same budget, same numbers, but we can see the increase in number of staff and the increase in this in the budget. So we can look at the percentage increases and then see whether over time ASIC is growing in a similar fashion. After all, even if you have a smaller capital market, you still have similar complex players, markets, similar complexities. You are part of this global system. So similar activities are expected from this regulator in Australia. I think I'm sharing it now. So what I did is basically, I looked at SECs and ASIC staff increases over time. And what I found out is that ASIC staff increased by 18% in the past 23 years. But comparing it with SEC, this increase is really minimal. SEC had about over 65% increase in that time. And this is actually on top of these major enforcement activities continuing to happen in complementary regulators, the state and other federal agencies. So many argue that there's a stark correlation of decrease in staff numbers with follow-up severe market failures. And there are two quick examples here in this slide. The underlined red parts are my examples. So what I have here is that first one is, let's look at ASIC, that's the orange one, orange line. In 2014, when Commonwealth Bank broke out, the scandal broke out in Australia, ASIC was criticized for not being tough enough, not going after these fraud scandal, the wrongdoers. And then the Senate had actually demanded a royal commission But when you look at what happened on those years is actually ASIC had its funding cut by 12%. With budget cuts, the number of ASIC staff then dropped, I think, about 100 by 100. So 100 staff all of a sudden disappears from this regulator, and then it's you know, criticizing is okay. It's so long as it's constructive, right? But when you lose 100 staff and when you lose your budget and expected to do all things the same way, it's kind of interesting. But it doesn't only happen to ASIC. Looking at US, looking at SEC, the blue line on top, what you will see is that from 2005 to 2007, number of employees in the SEC kept decreasing. And of course, soon after that, global financial crisis happened. And later, many argued that SEC couldn't step in and do many things right away because of these staff cuts on those years. It's kind of stopping our regulators do what we are asking them to do with those staff cuts. And staff cuts are actually very much correlating with the budget cuts. And if you turn to budgets of these two regulators, it's even scarier. When you look at the SEC budget, I mean, I think this is, I don't even need to explain, these lines are so obvious that SEC's budget just skyrocketed. Okay, we don't have to be at the same level, but do we see a similar increase? When we look at that, we don't really see an increase. Actually, after the global financial crisis, SEC's budget kept increasing no matter what. Whereas, so we are looking at this area now. It kind of, when you look at ASIC, it kind of decreased. There are some, fluctuations, but, staying about the same, not major increases along the way over the past 10, 20 years. So if there is some increase that we can talk about, it is pretty modest compared to SEC. So SEC starts with 300 million in 1995, and this goes all the way up to 1.6 billion US dollars in 2019. And this actually is, one is in US, other one is in Australian dollars, so it's kind of weird. So I converted those to Australian dollars both, but it actually is even more worrisome when you look at that. The gap widens even further when both are in Australian dollars. So it is a very limited budget. I talk too much and too fast. I hope everything is clear so far.
No, everything is wonderful, wonderful, Zara. But we're going to have to pass to Kathy in a minute. And do you have any comments just before I do pass it to Kathy, and then we can come back to any other issues you want to raise in the question?
Yeah, I will just have one more minute, if I may,
sure.
And I will be done. I have one tasty slide about apples and oranges. And let me say it up front that comparing the two regulators is not that easy, and most of you are thinking, oh yes, they are two different animals. So what are you doing here? And this because of all these differences, but we are trying to see what is it that we can get from, what is the insight that we can have from SEC to understand that changes over time. And what I wanted to argue here is that, and show, is that while regulatory oversight of ASIC expanded enormously over the past quarter century, its capacity to do it did not grow as much. So if we are expecting ASIC to do all these things that with laws and regulations are demanding, so we have to equip them with the tools that that will allow them to do all these things. Otherwise, we are setting up a giant regulator for failure without allowing them, giving them the tools that they are required to have. All right, I think I should stop here and then maybe clarify further during the
Yeah.
Q&A. Thank you.
Thank you so much, Sarah. And we're going to pass over now to Kathy Armour. So Kathy, if we can have your response and comments.
Okay, thank you very much, Jennifer, and thank you, Zara. I've really enjoyed reading your paper and the presentation today. And as Zara is a former New Yorker now living in Australia, I have at one time, as Jennifer mentioned, been an Australian living in New York. And I loved your theme about things kind of rhyming, because when I lived in New York, it was just the other day, but it was a time of, best described by the literature of the time, of bonfire of the vanities and barbarians at the gate. And it seemed a precursor to another period of great focus on the regulators. So I'm really keen to speak about the comparisons that you're making today. I think they're really interesting. But before going to that, I just wanted to take advantage of the platform here to mention, for anyone who is a really eager beaver, that today at ASIC we've released our corporate plan for 2020 to 2024. Now that is sort of building on an interim plan we introduced back in June, which was designed to explain what our priorities are going to be given the COVID-19 pandemic and the impact on our financial sector from that pandemic. So the corporate plan today is building on that. Our focus over the next 4 years is going to include, amongst other things, I just wanted to sort of raise a few of them with you. We're really focused on promoting confident participation in the financial system as a means of supporting our long-term economic recovery. We are still maintaining our focus, I think this is a bit of a topic of today, on deterring poor behaviour and misconduct through applying our why not litigate discipline. And we're very keen to also drive cultural change using all of the regulatory tools available to us. We're really keen to ensure we improve firms' management of key risks to prevent and mitigate harms to consumers and promote a healthy financial system and economic growth. We're focusing on addressing consumer harm in the environment we're coming into with elevated debt levels and hardship. And of course, we're focused on delivering as a conduct regulator for superannuation, which is one of the Royal Commission recommendations. Now, we're going to continually assess what we're doing, and I'd really appreciate, and I think everyone at ASIC, and particularly in the Commission, would appreciate any feedback you might have on the corporate plan. It's a living document. We hope you appreciate that we do approach our work in a dynamic way. So if you have any immediate or future suggestions about focus, please let us know. Now, on the topic of feedback, one of the delights of working at ASIC is the sense of working for the benefit of our community. And we often describe our professional job as being something we do for good reason. We actually just have that on the back of all of our cards. Against this, to be effective in doing our job for the broader community, we do need to, and we appreciate the regular feedback we get from all manners of folk in our community about our actual and perceived areas of challenges and needs for improvement. And it is really particularly valuable from my perspective to have academic attention focused on aspects of our work. The type of measured analytical work from the academic community is really valuable to us, and we do take notice and take it into account in all of our assessments of our work. So Zira, thank you so much for your work here. It's much appreciated. And I thought I'd just first talk about some of each of ASIC and SEC's area of responsibility. I know you raised the apples and oranges point. And it is right, no two regulators are the same and our markets are different in many ways. But I think there's much merit in examining and analysing and where it's appropriate, trying to emulate the approaches of other regulators. And I think apples and oranges together can make a nice sort of fruit juice, so why not? So I thought I'd run through some thoughts of the likenesses and distinctions between our two countries. First, the US is a big source of foreign capital into our market here in Australia. It is the #1 foreign investor in Australia. At the end of 2019, US investment was over $980 billion here, or 25% of all the foreign investment in Australia. So the approach that investors in the US see from their market regulator is something that I do think is and should be relevant to us in Australia. Now, while the US markets are much larger than our Australian markets, in relative terms, we don't do too badly. So during COVID, for example, we've seen the Australian equity markets punch well above their weight in global terms. Since the pandemic began, we've seen more than $36 billion raised by around 180 ASX listed companies. Now, on an outright basis, that puts us around a similar level of new equity to that in the UK, which again is a much larger market, and behind only the US. So on a relative basis for the size of our economy, I'd have to say the scale of activity is not so different between the two countries. Then another critical difference between the ASIC and the SEC, which I do think is important for us to bear in mind in this conversation, is that ASIC does not have, and it's never going to be able to have, an administrative sanctions power. So we can't on our own impose a monetary penalty or disgorgement. We cannot impose fines on the firms we regulate. We have to pursue action through the courts in order to impose a pecuniary penalty. And this inevitably impacts the enforcement approach and track record of each agency. We do have very limited powers to issue infringement notices in relation to some particular sections of the law, but even then it's clear those infringement notices are not a finding of a breach of law. And my final opening observation, as you've made clear, is that the US market has many different regulatory players, self-regulatory organisations, state regulators, as the two sort of standout differences. Interestingly, we both have the similarity of private litigation. Now, the environment in Australia is not as litigious as the US, but there's nevertheless a class action presence in Australia. And for many years, we've had private actions in relation to what we call securities class actions, but increasingly we've started to see class actions in relation to breaches of the financial services laws. So let me just expand on ASIC's approach to enforcement. As Zara has identified, this was subject to criticism by Commissioner Hayne and indeed on previous occasions. And we've made it clear that we're adjusting our enforcement posture. As we heard the criticism during the Royal Commission, especially in the interim report, we asked ourselves what we needed to do to change the issues being raised. And we decided to conduct an internal review of our approach to enforcement. We reached out to third parties to get their benefit, including an academic, and we spoke to our regulatory counterparts, including the SEC. Indeed, we examined the changes the SEC had made in response to those post-GFC criticisms and thought about whether or not it would help us. As part of this exercise, we really wondered what the nature of the problem was that we were seeing being articulated. We knew it couldn't simply be a matter of perception. There was really a problem because it was being so forcefully put. But what did we need to do better? Was it a matter of our case selection? Was it the tools available to us? Had we entrenched in our organisation a system of assessing matters that led us to make strategic choices that weren't really optimum? Was it simply down to whether our performance in doing our investigations or in litigating was adequate or not? And it was interesting. We'd given evidence at the Royal Commission on our enforcement record, and leaving aside our summary enforcement actions, which are more compliance actions for people who may file their accounts late or something like that, and there is a substantial volume of that action, but just looking more at the complex matters which are more equivalent to the SEC enforcement. Over the last 10 years, we brought actions, civil or criminal, so in criminal we investigate and prosecute through the DPP, about once a week, every single week for that 10 years. So we didn't feel that there was an insignificant degree of court-based enforcement. But nevertheless, we realised we had to ask why there was a view that we, to quote, rarely went to court to seek public denunciation and punishment for misconduct. We asked ourselves, had we been too risk adverse in our use of public monies in our enforcement work, particularly because we don't have the administrative enforcement powers. So we've had to think about the costs of conducting litigation and also the liability to adverse costs if we were unsuccessful. And there were two other factors that I think we asked ourselves, and we probably recognised they had shaped our approach to enforcement. One was the priority we'd placed, particularly in the matters which are now called fees for no service, in pursuing remediation for consumers as a priority before we look to court denunciation of the misconduct. And secondly, to the absence of effective penalties or remedies. And the loud and clear feedback we received on the question about the priority we placed on remediation was that we needed to get better at, to use the phrase, walking and chewing gum at the same time. So focusing both on penalties through the courts and remediation. And we see that the directions power that is in the sort of legislative process, it's coming up, I'm hoping in the next session, to be considered by the government, by the Parliament, will help us really efficiently regulate remediation activities. And that will give us more bandwidth, if you like, to focus on the enforcement aspects relating to the misconduct. The second factor, which is a penalty regime, is an area where change had been agreed, and coincidentally new penalty laws were underway and they became effective last March. And as a result of that change, civil penalties now apply to misconduct that before actually had no penalty, and penalties have been strengthened. So we've got maximum civil penalties of just over $1 million for individuals and 525 million for companies. I know it's still below your Goldman Sachs example. Maximum prison penalties have increased for the most serious offences to up to 15 years, and the infringement notice regime has been extended, and there is now an availability through the courts of disgorgement remedies, which we didn't have previously. Before this change, many of the instances of misconduct which were referred to us from the Royal Commission related to the breach of a cornerstone obligation for a licensee to act efficiently, honestly and fairly. There was no penalty attached to that until these changes came into place. And many of the matters that we were criticised for, because we pursued court enforceable undertakings, actually related to potential breaches of that provision. So as a result of all of that, as you know and you've covered, we did review our approach to enforcement, adopt the why not discipline why not litigate discipline, and established our Office of Enforcement. Now, if we have time, I just thought I might put up a slide, if Janice is able to do that for me. I'm not quite, oops, here we go. And if we can move to the second slide. Yes, so this is taking Zara's slide and just adding a few extra things to it, which I think have, at least at the time I've been at ASIC, been quite important. I'm just raising the 2010 change because I think this is an interesting one. We took over real-time market trading supervision. Many parts of the world, not everywhere, but certainly in the US, that real-time supervision resides with the exchanges themselves. Interestingly, we think that by taking that over, we've enhanced our enforcement capabilities, and this was something the capability review of ASIC did flag as well. But as already been covered, as well as those particular items that Zara had highlighted in the slides, the Senate inquiry into the performance of ASIC was quite pivotal because it really, for the first time, started to talk about some of the ideas that are key, one, to improving our enforcement capabilities, but more broadly, really fundamental issues like how we as staff, should we be part of the public service anymore? Should we be funded in the same way we were funded? And importantly, starting to talk about enforcement remedies. We put out a paper on penalties that in 2014 that really compared the penalties that under our legislation to that available to other regulators in Australia and also internationally, and that was then picked up through the Murray inquiry. 2015 we had our capability review, which again made recommendations that helped us internally adjust what we were doing, but also that led to a number of matters being accepted by government, including changing how ASIC staff were employed and how ASIC was funded with an industry funding system. And then in 2018 was the Enforcement Review Task Force report and government response, which has led to the changes to the penalty regime. So they were really, really important things from our perspective. So thank you, Janice. That's all I needed the slide for. And I just finally, I think, let me just say a note about budget and staffing levels. There's not a lot I can add because ASIC's budget, like that of the SEC, is a matter for government to determine. But I do think it's worth calling out two very significant developments to the way we're funded in recent years. The first has been the introduction of industry funding for ASIC. So like the SEC, ASIC's budget is still determined by Parliament, but funding is recovered from industry. But unlike the SEC, which I understand it's a levy on listed equity market transactions, our funding is recovered using a user pays principle. So the concept behind it is that businesses that require more intensive regulatory oversight pay more for the regulation. And I think we're into our third year, and it will be interesting to see whether there are changes in the way business behaves and adapts to this regime. We're hopeful that as a result of this regime, there may be some adjustments. About 95% of our regulatory costs are recovered through this industry levy. There's another 5% for fees for things like making an application to ASIC for relief. The second thing to note there has been significant changes to our budget in recent years. Now, largely this is because of extra things that we've been asked to do in connection with adoption of the recommendations of the Financial Services Royal Commission. But critically, there has been significant increase to bolster our enforcement capabilities. So our budget for 2019-20 is $403 million. remember that includes budget to run the companies and business registries that we run. But we did receive an increase in funding for over a 4-year period of 404 million. That's cumulative, not each year, to deal with the matters I mentioned. And notably the enforcement special account, which is the account which we are able to utilise for significant enforcement matters, has been increased quite substantially. So they were the significant matters I wanted to raise. Really, I suspect I've exceeded my time. So Jennifer, back to you. We're happy to take questions. Well, I'm happy to take questions.
Thanks so much, Kathy and Sarah. So we do have some questions coming through at this point, and I will be going through them. So first of all, this one I think we might have already covered from Jason Harris at Sydney Law School. How would you compare the regulatory remit between ASIC and the SEC, not just enforcement actions and resources, but breadth of responsibility? And Jason points out, you know, ASIC has a broader responsibility than the SEC. I think we've covered that since Jason asked the question, but any further comments? And Jason, if you have got any further comments, feel free to put them in the Q&A box as well. Kathy?
Jennifer, I was just going to say, for us, so I think the US, the emphasis is on size, if you like, you know, the size of the economy, the size of the market. But for us, in an Australian context, we do what the SEC, the CFTC, the various departments of state with company formation, etc., do. We do what the various state insurance regulators do. So we have the financial reporting and auditing standards, which again is done partially separately again in the US, and we have the insolvency practitioners as well, and we have consumer credit. So those things, as to my understanding, are all done by different agencies in the US, but we don't have that size. So yeah.
Sarah, any comments on that?
Yeah, definitely. 2 points. First, looking at the fact that SEC regulates only listed companies, whereas ASIC regulates all companies, actually freaked me out when I first came here and then heard about that. But this just didn't make sense. Like all companies, even small companies, proprietary companies. So this is a great task, and it actually warrants on its own to have a specifically more staff and specifically allocated budgets to deal with sheer size of the companies under regulation. So that's one point. And again, like not having any complementary agencies at the state level enforcement activities is just shocking. You know, how come a federal system had you know, corporate law at federal level, not at state level, was shocking as well. But anyway, so this is a very different environment, and that's actually everything that we see when we look at these differences warrants that ASIC needs further support, further staff, further budget, because it has a lot on its shoulders. You know, that's, I mean, corporate insolvency law to state insurance is like just unbelievable that ASIC is doing it all.
It is interesting that you point out that those many other regulators in the US as being a positive, because I must say during the global financial crisis, I thought it was a huge negative because there were 132 different regulators that were somehow involved in the financial crisis, as opposed to, I think, a much, cleaner regulatory response in Australia, under a Twin Peaks model. Yeah. But let me move on. We've got a question from my colleague Drosso Stamboulakis here. This is primarily for Kathy, although I'm sure he would like your views as well, Sarah. How does ASIC see the use of securities class actions and how they, oh, sorry, it's bouncing around on me, and how they affect regulatory action? Are they complementary, filling a resourcing gap, or are they a useful source of information for enforcement proceedings by ASIC? or might they interfere potentially with remedial action that ASIC might want to have, such, you know, for remediation? Thinking about fees for no service. So how do you view them? Are they competing with you? Are they filling gaps for you, Kathy?
Well, I think there's a different purpose. I mean, we've already seen, and I think the remediation cases are a good example of how difficult it is for a regulator to effectively, especially a regulator with our job in our community, to get around and achieve everything for everyone. You know, so for us, if we're focusing on dealing with the misconduct, then class actions and any sort of private litigation can be a very effective vehicle for seeking the compensation. And so I think there is a place for them. I think it's quite different. I certainly don't see that we step back. I thought perhaps part of the question might have been suggesting we might step back and watch what happens from a class action. That's not our interest. In fact, most of the time we're certainly in there before a class action's commenced. We may have made a decision, as we have in numerous cases, that the conduct didn't merit a regulatory action, but generally our investigations are well and truly underway beforehand. So we don't see it as a substitute, if you like, but I think it does go neatly to this point about complementary or even competitive solutions can be productive depending on the circumstances.
Yeah, and I think it ties in with Zara's comment in the US about the push to get admissions of wrongdoing, because, you know, my guess is there's a big fear there of admitting wrongdoing and then having the class action following the wake of that admission. We've got a question from Bruce Dyer here. ASIC seems to have had great success using big data and AI to enforce insider trading laws. Does the efficiency of that make it a better and potentially fairer form of enforcement? Speed cameras rather than ambulance chases, question mark.
Well, look, I think that's why I mentioned the change in the frontline market surveillance to us in 2010. I think that really has made a huge difference. We've been able to be quicker to the issues. We've been able to call out trends faster as well, so that something that might be falling short of individual misconduct, nevertheless we can flag that there's an issue, and certainly we now have all the reporting of the vast amount of derivatives transaction over both the retail derivatives and the wholesale over-the-counter derivatives, and we're working out how to leverage that data, because obviously there was substantial misconduct on a global scale in relation to benchmark rigging and FX. And again, we want to take advantage of that sort of information as well. So I agree with Bruce's comment. I think there's quite a lot of flexibility if we can find ways to utilise big data well.
So we've got an anonymous question, which I think might come from a student, and then a definite student question, and I think they link together. So I'd be interested in your views on both those questions. One is, you know, the fact that in the SEC, it is seen really as a badge of honour to have worked for the SEC. And often, you know, students come out of law school, they work at the SEC, and then they get airlifted into one of the major firms. So that's one of the questions about, you know, what can law schools offer to ASIC in terms of student pathways into working for the regulator. And then the other question that I was looking at was asking about the culture of ASIC, and, you know, does Kathy have any advice for law students who would like to work for ASIC in the future? So, you know, I think both Zara and Kathy might have some views on that. Zara, I'm sure you saw as a student at Columbia Law School and Fordham a number of your, you know, compatriots going into work for the regulator. So any views from you on the different cultures there and in Australia?
I will quickly say that it's highly regarded in the US to work for SEC, and many academics actually do work for, I mean, in corporate and securities law area, do work for SEC and then go back to academia after that, rather than, you know, going into being a practitioner. It kind of sounds more impartial, but it's invaluable because most of the classes then very much focuses on these, you know, enforcement actions, the cases. It's very practice oriented, and it's hands-on experience and an amazing collaboration between academics and SEC in terms of research. It's, I think, strengthening the academics, and it's strengthening the regulators, having such a strong research and then having such a practice-oriented teaching actually helps a lot. And I do think that it is really highly regarded and very much privileged to be working for SEC in the US. So many people do try their best to get in there and have the exposure, have the experience.
Which is great for any regulator. Do you find that, Kathy, with ASIC, and how do you build that kind of pathway?
So I totally agree with what Zara said. I found it really interesting working in a US law firm. It was completely accepted that government service was an important part of your career, and private practice valued it. I'm not sure that that happens in Australia, and I absolutely don't understand why not. And I think it's really quite unfortunate that it doesn't. The ASIC graduate program is rated, on the surveys that we take, is rated the third best graduate program in the country. It's the #1 for last year and #1 for government enterprises. So there's a lot of demand to come and work in our graduate program, but it really, I think it doesn't stop there. I think it's understanding that there is a value from any ASIC employee, whether they're a new graduate or you know, someone with 5 or 10 years experience under their belt, because I think it reflects a little bit on our broader financial services community, that it's not always the case, and on our legal community. It seems to suggest to me that only if you think in a certain way do you have value, not if you think in a way that might have had a different focus or different levels of experience. And I think that's a real pity. And I think it would be really useful if we could have a more productive flow through of people between the regulator and, frankly, from the regulator into other careers, because I think that will enhance and improve the people who are working at ASIC's interests and opportunities as well, which is, I think, is an important thing.
Maybe Australians just don't like regulation and authority, the old convict heritage, you know, that's maybe the problem. Now I've got a question from Rosemary Langford from Melbourne Law School here. Rosemary has asked whether the why not litigate approach might discourage companies from cooperating with the regulator if they fear that they're going to be hit with legal actions. Kathy, I'm sure you've confronted that argument.
I just find it so interesting, isn't it? Because in any bargaining situation, people need to have their own positions and the power of their own positions. And it's a little bit like the litigate ready argument that the SEC had. They changed their bargaining position and the strength of their discussion. I find it interesting in Australia, there seems to be this notion that why not litigate is problematic because we're suggesting that litigation is a reasonable outcome. It's always been a reasonable outcome. You know, it's always been the main tool that we've had, and we're saying to people, this is a tool we're not concerned about using, and this is a tool that we will pursue, and how you deal with that is something that we'd like you to think about. I think there should be incredible incentives for people to think about talking to us and dealing with a matter of concern. And we have, to be fair to a number of financial institutions, we've found a very cooperative approach to accepting that there has been breaches of the laws and coming to agreed statements of fact and having efficient litigation. And I think that's very productive. But I'd be interested in Zara's view on this.
I think you covered it all really well.
All right, we have a question here for both Kathy and for Zara, and it is from Amanda Hartness. Hello, Amanda. She's asking the same question to both of you. For Kathy, what do you rate as the most effective suasion action, so persuasive action, I guess, by ASIC since the GFC, and what's the most effective enforcement action? And then she'd like to know the same from Zara, re the SEC. And we're running out of time.
I know this. Trust Amanda to come up with a difficult question that would require a lot of thought. You know, it's, for me, I'm not sure about actions that are just for the purpose of running a piece of litigation or a piece of court-based approach. There are two things that really stick out for me. One is one that I'm really proud of, and that is the way ASIC, combined with the other financial regulators, actually took a multi-pronged approach to ensuring poor conduct around financial benchmarks was dealt with. So that involved litigation, licensing, research, very pragmatic look at the fundamentals of the regulation. And Amanda would know this well because the ASX has ended up being, where she used to work, has ended up being the licensed benchmark administrator. So I thought that was a good outcome because it showed lots of elements of a regulator's tools and the benefit of working as part of a regulatory community. So that's one that I'm very proud of. But there have been lots and lots of suasion ones that have made significant differences. Reporting to financial advice in connection with life insurance was very, very instrumental in changing the way that industry is structured and dealt with. And there's all sorts of examples like that. It's hard to pick out a particular one, but Sarah, perhaps you.
My answer will be weird. I'll say it up front. So mine is not specific cases. What I've seen after the global financial crisis, being in New York, having a lot of friends working in these financial institutions, was that the investigate to litigate approach really freaked everyone out. As soon as SEC started an investigation, there doesn't have to be a follow-up action or anything. Just the fact that SEC started investigation, and they're not allowed to talk about it, but then you can see the purple faces. So, so it was amazing to see how effective only an investigation can be. How culture changes in the financial institution all of a sudden. Just this fact that this regulator investigates, asks all these documents, go through you, ask those questions, and freaks out everyone. And I've seen cultural transformation in these financial institutions from compliance, procedure, and all these departments, how they become more important, working closely with SEC, making sure they are doing everything right. And I don't think it has to be, these major, record-breaking settlements or major cases or imprisonments, but the fact that there is an oversight, there is an institution that these financial players, financial institutions are actually kind of afraid of, or like aware that there is this oversight is changing the world. I have to say, because if they're not afraid of these regulators, if they think that, you know, oh, SEC, we're going to handle it, that's fine, they will be ruthless. They can't do anything. But if they know that SEC investigates, has the power, can do it, and has the capacity to do it, then it's a different world. That's what I've seen a lot. I think just the fact that investigation itself is a big deterrent, I think, is the major thing that I'm impressed at all times.
So 2 very quick questions, and then we're going to wrap up the session so everyone can have dinner. I'm going to direct one of them to Kathy and the other one to Zara. So from my colleague, Liz Campbell, Kathy, she is asking very much along the lines of the class action question we looked at, of how does it fit in with your regulatory views? What are your views on deferred prosecution agreements? And, you know, are these going to be a valuable addition to Australian law, or are these going to be part of the problem of cutting down on litigation where people don't have to, you know, admit wrongdoing? What's your view on them?
So Jennifer, and Liz, I'm sorry to probably let you down with this, but I think this is a matter that's, you know, currently before government, and so it's not really something that I should comment on. But, you know, I think it's interesting how those sorts of agreements have been utilised, particularly in the US. And in some cases, particularly in the financial crime space, there's been, you know, they've been seem to have been very effective tools to ensuring a bolstering and adjustments of behaviours. So
yeah, and Liz does make the point in her question that the ALRC report came out today, suggesting that 1 per year were likely, which is certainly not a lot. Now, I think we've got time for one more question, and this one I'm going to direct to you, Zara, from Mamaloni Razwoko, who is a PhD student at Monash. And she asks, and you may have covered some of this already, how does the difference in the state securities regulation affect the coordinated enforcement by the SEC as compared to ASIC's enforcement action? So, you know, this goes to that, you know, multi-layered regulatory approach you were talking about earlier.
Yeah, I actually kind of covered it very, very briefly. It's depending on where you want to look at it. It's kind of a competition, it's a chaos, and every state has their own power. But I think Delaware and New York are the ones that, you know, we often will look at, sheer size of companies listed.
I might change the question slightly to look at it more at an international level, which you and Kathy could both respond to, because of course in 2007, the SEC was finding it difficult to regulate extraterrestrially or extra, you know, judicially. And so it was interested in entering into a mutual regulatory agreement with ASIC, which then fell through. But ASIC has a lot of those international mutual recognition agreements. And, you know, so when we're looking at that sort of global regulatory picture, how does the SEC differ compared to ASIC there?
That's a really good question.
Well, that's a good one to end on then.
The first answer should be, maybe arrogantly, as SEC will often, at least up until the global financial crisis, was not interested and keen on having this coordination between, you know, or at least mutual recognition between different regulators around the world. I mean, I did a lot of research on accounting standards and how they didn't even recognize, you know, Canada cross-listing for Canadian companies with their accounting standards. So it's just one aspect, but the SEC often is not an institution that will be interested in recognizing other institutions' decisions or comply with those. It is an independent institution, will not just accept anything from outside. That's one thing. But then what happened after the global financial crisis, and what's happening is actually there's an interpaper that's recently accepted, hopefully will come out soon. And I'm talking there about how global financial lawmaking is happening very differently at a different stage right now. The laws and regulations happening at the global level, and then countries are now mere adopters of this. It's a lot of coordination happening, you know, from IOSCO to many aspects, like look at Basel Committee and all these things, G20s, and everything goes on, and there's a mechanism of coordination, cooperation that is unprecedented, and that's one of the reasons we actually are talking about how hard it is to simplify, deregulate, because it's all about this coordination at the international level.
I think after that failure of the 2007 SEC ASIC, or well, I shouldn't say failure, it was put in place, but it just really wasn't used as the world went into the global financial crisis, and then it expired. But ASIC really then took that model and has got so many regulatory agreements around the world. Kathy, is that right?
So I'm not sure what, Jennifer, what you're meaning by failure. If you're talking about 2007, was that the proposed debt markets?
No. It was a mutual recognition agreement, and Australia was the pilot. The US had been looking at Europe and then didn't enter into it with the UK because you know, there were too many countries in the EU it didn't like. And so it entered into a pilot program with ASIC, but then it was never really operational.
It may well have been overtaken by something that's called the multilateral MOU, which is an IOSCO sort of sponsored MMOU, which is the main one that we utilise in particularly cross-border enforcement arrangements, and maybe that was what ended up happening. So we exchange information and conduct joint sort of inquiries, largely through the auspices of the IOSCO MMOU. And certainly we have a really rich engagement with all the US regulators that really depends on that MMOU, which, so ASIC and SEC and the CFTC, if you like, are the sort of pillars there. And obviously, if the matter is an SEC matter or a CFTC matter that goes to the Department of Justice, comes in through those auspices. So I think probably internationally, as Zara was saying, the world's post-GFC is perhaps, regulatory world is perhaps becoming more used to the need for the cross-border coordination and discussions and cooperation, and it's certainly something that we're really actively focused on. And you'll often see, if we have enforcement outcomes, that we will thank our regulatory counterparts in other jurisdictions who've participated in the outcome, and they will often thank us in their announcements. But yes, so it is an area that's developed.
Well, I'm going to thank you both for a wonderful seminar, and also thank you to the audience for great questions that were coming through. I want to tell you all, just before we do our leave meeting, the next seminar is on the 23rd of September, and that is going to, oh, here we have a slide. Thank you, Janice. Another person I really want to thank for all the work in the background. So managing management buyouts, that the speaker is going to be my former colleague, Andrew Tuck, who's now a professor at Washington University School of Law, and Susanna McNay from Gilbert and Tobin. Susanna is just back from working in London, and she is going to be giving us a viewpoint from Australia and from the UK. I think you'll all hear from Janice tomorrow. Monash has changed its rules about being on email lists, and you all have to fill in a form or something. So we'd love to keep you on our mailing list and have you along for future events. But thank you all so much for coming tonight, and thanks to the speakers. Goodbye, everyone. Have a good night.
Thank you.
Bye. Thank you.